Hello, viewers. This is Major General Neelendra Kumar for the YouTube channel Lex Consilium Foundation, and in the playlist in Semilia here in conversation with the senior advocate Sudhesh Pai, and he is talking about some of the legendary, brilliant minds that have been in the Indian legal judicial landscape. Now, the next name that comes to our mind, which you have covered, is Mr. MK Nambyar. And in particular, I would request you to please tell the viewers about MK Nambyar's role in AK Gopalan's case.
MK Nambyar is the father of KK Venugopal and is perhaps one of our most illustrious lawyers, an original thinker, a constitutional lawyer in every sense of the term, whose role in building up of our constitutional jurisprudence has been stellar. To talk of Mr. Nambyar's career, he began in the Mofussil court in Mangalore, a family case which they won in the Madras High Court and which went up to the Privy Council, made him go to England to instruct the Queen's Council, King's Council there. So he stayed on, did his masters from the London School of Economics in constitutional law. Great foresight in those days. This was in the 1930s or so. Was also called to the bar, came back and continued his practice in Mangalore, where very soon he became government pleader and public prosecutor. In fact, that was during the time that, again, after the 1935 Government of India Act and the first government, where Rajaji was the prime minister, premier of the Madras presidency. For many years, Mr. Nambyar was government pleader and public prosecutor in Mangalore. 1947 or so, destiny intervenes, so to say. Mr. Govinda Menon, who is you have Mr. Gopal Shankar Narayan, senior advocate in Delhi. His father's father, his grandfather, his paternal grandfather, who ultimately was and died in harness as a judge of the Supreme Court, was elevated to the bench, and he asked Mr. Nambyar if he could move on to Madras and take over his practice. Mr. Nambyar steadily accepted. That's how he moved to Madras almost at the time of the independence. Slowly but steadily, he built up his practice there. And it so happened when he was arguing some matter in the Madras High Court, V.G. Rao, who was himself a lawyer, and you have V.G. Rao versus State of Madras in 1952 Supreme Court.
Yes.
Barrister, yes. Was impressed and said, and that was the time that Gopalan, one of the leaders of the Communist Party, was preventive detention. So he asked Nambyar whether he could take up the case, because he was impressed that Nambyar was, quite sound in constitutional law. Though at that point of time, he was not known to be a constitutional lawyer, and there was not much of a practice in the district court. You don't have it. So Nambyar accepted, and the rest is history. It was perhaps one of the first cases, major constitutional law cases, and Nambyar appeared for the petitioner with Setalvad as Attorney General defending the government. And in fact, Mr. Setalvad himself writes that Mr. Nambyar's argument was of a very extraordinary caliber, and there was pin drop silence in the courtroom except for the noise of Mr. Nambyar turning the pages of the law report. That was the kind of tension with which he was heard. But unfortunately, except for Justice Faslali, the other 5 judges upheld the law. And in fact, Mr. Nambyar himself said, and he will believe that the Constitution, almost at its inception, a death blow was struck. But there is an interesting anecdote which I heard much later, and that's not mentioned in the book. Chief Justice Patanjali Shastri was one of the judges on the bench. In an airport lounge, Patanjali Shastri, Nambyar, and Setalvad were all together. It happened. It seems Patanjali Shastri said Mr. Nambyar's arguments were very correct. We were not right in not accepting it. Possibly, the personality of, we were overwhelmed by the personality of Setalvad.
Okay.
Yeah. This is what Patanjali Shastri is reported to have said. So it only brings out the quality of Mr. Nambyar's soundness.
Arguments.
Fortunately, every argument of his 20 years later was accepted, and Gopalan became a dead letter.
A landmark decision. Beyond AK Gopalan's, then an occasion rose when the Dr. Dieter Conrad's argument with regard to the Constitution and the basic structure. This was came up. This was presented before the Supreme Court. Would you like to put it in the proper perspective?
Yes. Of course, after Gopalan, Mr. Nambyar appeared in any number of constitutional matters in the Supreme Court, and there were occasions when he would be arguing in Cochin, Kerala, High Court, and then taking a flight. Those days, flights took 7 to 8 hours from Cochin to Delhi. Then he would reach Delhi and argue in the Supreme Court. His practice was, really very, very widespread. And he would handle 3, 4 final hearing matters a day, argue for half an hour with just the main points, but absolutely thorough in all that he did. The case you're referring to is Golaknath. As you know, the amendment, the Article 368, the power to amend the Constitution. The first amendment was challenged in Shakari Prasad's case almost at the very beginning in 1951. The Constitution bench, presided over by Chief Justice Patanjali Shastri, upheld the amendment and said it is within the power of Parliament. There are no limitations on the amending power. That was also the first amendment, as you know, had also introduced Article 31B and the 9th schedule. Acts put in the 9th schedule were immune from challenge on the ground that they infringed fundamental rights. This was done to shield agrarian reforms from attack. Because government found, and I think we can't blame them, as we all know, one of the planks on which the Congress came to power was to usher in a more egalitarian society. So land reforms was high on the political agenda. The courts, in some sense, were striking down all the land reforms legislation, so virtually undoing or obstructing the program of the government. And therefore, the First Amendment, at that point of time, it may not be wrong to say that, it may not be right to say that it was not a desirable thing. And certain enactments were put in the 9th schedule. But what happened is, thereafter, any number of enactments were being included in the 9th schedule, and not every one of them was necessarily anything to do with the land reforms or agrarian reforms. So after the 17th Amendment in 1964 to 65, again, Sajjan Singh's case, the majority upheld the amendment, but doubts were raised. Chief Justice Budolkar said whether you can just amend the Constitution as it is, or is there something really fundamental, basic to it, a core, which cannot be altered. And Justice Hidayatullah posed the question whether fundamental rights are simply the playthings of the majority, that you can interfere with them. And you also had a judgment to the Pakistan Supreme Court, Chief Justice Cornelius, who had used that expression, basic features. When you amend, of course, in a different context, when you amend, but you can't amend to undo the whole thing. There's certain things, the core of it has to be retained. It was then that you had Professor Dieter Konrad, professor of the University of Heidelberg in Germany. He delivered a lecture at the Banaras Hindu University, I think in 1965 or 66, on implied limitations on the amending power. Of course, that was essentially with respect to the West German constitution after the Hitler's, where there is expressly certain provisions which they say cannot be amended. Anyway, the theory propounded was that there are certain basic things which cannot be amended. Nambyar borrowed a copy of that lecture, and Conrad said, of course, you can give it to the court, but please give the whole of it, not a truncated version.
Not selected excerpt.
Yes. So the whole lecture was also presented to the court in Golaknath, but really, Golaknath's case did not deal with this aspect. Though Chief Justice Subbarao said that fundamental rights are beyond amendment, you can amend, you can't amend Part 3. This was not really dwelt in Golaknath, but it was only later in Kesavananda, where seeds that were sown by Nambyar, the seeds sown by Nambyar were brought to fruition by Alkiwala by his forensic brilliance in the Kesavananda. This is the background of Professor Dieter Konrad's thesis.
Thank you very much. You very well brought it out. The viewers may like to stay on with us. This conversation with Mr. Sudhesh Pai about the legends in law would continue. Thank you very much.